the stream is on. Yeah, now we're
Let's
streaming
start.
live on
Let's
YouTube.
start.
Let me check if Instagram is live. Um, Sorry, yeah, I think. Okay, I'm unable to see whether it's live on LinkedIn. Let me just refresh my browser once. Yeah, we're live on LinkedIn as well. Um, Good evening to everyone who's tuning in. Today we will be discussing upon the theme of the Tamil Nadu Verdict and limits of gubernatorial power. The office of the governor, often regarded as the linchpin of India's federal framework, is increasingly becoming a site of tussle between the union and state governments. While the governor was envisaged as a neutral constitutional functionary, acting as a connecting thread between the union and state governments, the rise in number of controversies and contestations surrounding this post have drawn serious concerns about the politicization of gubernatorial powers. The 2025 Supreme Court judgment in this regard marked a turning point in attempting to address this important issue. The landmark judgment, delivered in response to a writ petition filed by the Tamil Nadu government due to a protracted inaction by the state's governor on the passage of bills, tests the boundaries of doctrines of separation of powers and the basic structure in India's federal setup. Allow me to introduce our speakers for this evening to you. Dr. Shruti Bedi is Professor of Law and Director at the University Institute of Legal Studies, Panjab University. Very warm welcome to you, ma'am.
Thank you, Tia, for having me on this platform. Looking forward to the discussion today.
Thank you, likewise. Uh, Dr. Ashutosh Kumar is Professor at the Department of Political Science, Panjab University, Chandigarh, India. A very warm welcome to you as well,
Thank
sir.
you. Thank you, Tia. Thank you.
Okay. Um, So, Professor Kumar, as you discuss in your article for EPW, the prolonged inaction of the Tamil Nadu governor on the passage of bills without communication, justification, or reference to constitutional mechanisms triggered a crisis of federal functionality and democratic accountability, leading to the landmark Supreme Court judgment on the same. Before we examine the recent Supreme Court judgment on the powers of the governor in more detail, can we perhaps begin our conversation with the constitutional design of the role of the governor? How did the Constituent Assembly originally envisage this position?
Thank you, Tia. I think this is a very pertinent question you have asked because the original intent of the Constituent Assembly, that is very important because when these offices were instituted, there
Right.
were certain ideas in the minds of the Constituent Assembly members that what is going to be the role and how they are going to be appointed and what is going to be the safeguard, whether it's election commission or the president of India, any office or the governor or several articles also like 356 and all. So that can be very revealing. So if
Right.
you see the debate on the office of the governor, the main issue was about the appointment. That whether, because as you know, India has adopted parliamentary model of government and also has got this federal model. So these are the two things, and there we are very close to Canada. We are not so close to US where there is a presidential system and a federal system.
Right.
So the Constituent Assembly members decided they had several arguments. One was that the governor should be directly appointed by the universal electorate from the state, just like in US. That
Yeah.
was not accepted because it was thought that the office of the governor would be, if it is directly elected, then the governor would be center of power, and there would be a chances of conflict between the governor and the chief minister or the council of ministers.
Right.
And as you know, under Article 163, governor is supposed to go by the advice of the council minister. That is the basic crux of a parliamentary system. Then
Yes.
there was also suggestion that the governor should be appointed, elected by the legislative assembly.
Right.
That was also not accepted. The third was that the legislative assembly should prepare a list, and then the president should approve one of the name from the list. Then it was thought that if the president doesn't go for the first choice of the legislative assembly, then there would be a kind of hostility between the governor and the legislative assembly. So, taking all these things, it was finally decided that the governor should be appointed by the president under his hand and seal. So right
Right.
now the position is that the governor holds office during the pleasure of the president. What was
Right.
the intent? This is about the appointment of the governor, and of course, as you know, the Supreme Court in its recent judgment has made it very clear. In
Yeah.
1982, I think Ramaya case, the Supreme Court has said that there is no confusion about it. Governor holds office during the pleasure of the president. So governor can be removed any time by the president. Though there have been decision judgments, which I think Shruti would make you aware, that you have SR Bomai case and other cases, like you have the Punchi Commission and
Yes.
the earlier the this
Sarkaria Commission.
Sakaria Commission. They made it very clear that the governor post is very prestigious, the constitutional post, and it cannot be considered as subservient to the union government or union executive.
Right.
Then, if you refer to the debate, Nehru was very much clear that Jawaharlal Nehru, speaking in the Constituent Assembly, he said that the governor should be apolitical, governor should not be very much interested in politics. He should be a figure with a detached from politics and a
Right.
person, very eminent person. And
Right.
Dr. Ambedkar also talked about the position that he was very clear that the governor doesn't have much power. It's a basically a ornamental post.
Right.
So they were very clear that the governor position would be just like the president in a parliamentary system of India, or like the British monarch. As you know, we have followed the parliamentary system based on the British monarch. So that was the position. But then the Constituent Assembly, the last thing I would like to say, it was also made very clear that Brajeshwar Prasad was the person who finally he gave the proposal that the governor should be appointed by the president, right? And of course, as you know, president goes by the advice of the Council of Ministers under Article 74. But
Right.
then in the Constitution Assembly, it was also said that the governor, office of the governor, would be a link between the central government and the state government. So that
Yes.
way, the office of the governor is very important. The question you asked is very important for the harmonious relationship between the state government and the central government. So even if you consider the governor as the representative of the central government, and it was also said in the Constituent Assembly that the governor, and even in the Punchi Commission report, that the governor should not be from the ruling party. So
Yeah.
all those things are there, but as you know, Sarkaria Commission report and all, we would discuss it. So probably the basic intent that the governor would be over and above the party politics and would be a neutral figure and would be not so much interested in politics, would not be from the state and all. Those intents, those the basic ideas have not been really fruitified on the ground. So
Right.
theory and practice, the normative thinking and the basic practice. Thank you.
Right. Thank you for laying out the historical context so succinctly for us, Professor Kumar. Coming to you, Professor Bedi, in your article for EPW, you explain that the factual context of this case is illustrated of a deeper crisis in India's federalist design, particularly involving the discretionary powers of the governor under Article 200 of the Constitution. Do you think that governors over the years, such as in the recent Tamil Nadu case, have developed a pattern of bypassing the legislative assembly in their decision making? And further, why have the state governments, such as that of Kerala and Punjab, taken their governors to court?
You are not audible. Shruti, unmute yourself, please.
Oh, sorry, sir. Thank
Now
you.
it's okay.
I
Now.
had just put it on mute so that it's doesn't resound. And thank you for having me. Uh, See, before we start the discussion, I think it's great that Professor Kumar has laid out the political aspect of how this entire role of the governor was envisaged by the Constituent Assembly. And keeping that backdrop in mind, we have to understand the role of the governor is like like that of the president. He is supposed to facilitate, he is supposed to help. And when we talk of cooperative federalism, he is the link between the center and the states. And any kind of obstructionist policy which may be adopted by constitutional functionaries would
Yeah.
not help matters. Now, having said this, uh, Tia, you have asked about how the governors are behaving in today's times, particularly with respect to Article 200 and the requirement of assent. See, when we speak of the legislative process at the level of the state, the elected government of a state, which is representing the will of the people,
Right.
comes out with a law. And once it is passed by the majority of the elected representatives, it is sent to the governor, where the constitutional scheme envisaged that role of the governor as a formality, keeping the balance in mind. And also, in exceptional situations, the governor could take the stand that he would refer the bill only in exceptional situations to the
Right.
president. Now, over the recent years that we have been looking at the various states of Kerala, of Tamil Nadu, of Punjab, of Telangana, this Article 200 has taken on a negative connotation. It is being sort of used not to facilitate the legislative process, but to obstruct it.
Right.
And therefore, this whole aspect of the Punjab governor, or sorry, the government of Punjab or the government of Tamil Nadu that we are discussing, the case that we are discussing today at present, has come into focus. Particularly talking about today's issue and what happened in Tamil Nadu, and why was the government actually pushed to go to the Supreme Court for this, was I mean, there was inordinate, there was unexplained, and there was arbitrary delay
Yeah.
by the governor of Tamil Nadu
Right.
in acting upon the 12 bills originally passed by a duly elected state legislative assembly
Right.
since 2020, where the governor had taken no action. Either, see, Article 200 says either you assent,
Yeah.
or you return the bill to the assembly,
Right.
or third, you reserve the bill for the consideration of the president. So
Right.
none of those three were, no action was taken.
Yeah.
And this prolonged inaction, without any constitutional justification, without any communication between the governor and the government
Right.
of the state, led to what the Supreme Court has described in this Tamil Nadu verdict as a legislative deadlock. And that had the effect of nullifying the legislative mandate of the assembly,
Right.
and consequently it disrupted the democratic process at the state level. And we have this judgment being delivered on 8th of April of this year, and it has stepped on a lot of toes, it has raised controversy, uh, and the judiciary's role has been questioned. But
Right.
since we are gathered here, I think our job is to clarify, is to try and understand what has actually happened. So this is what I have to share. Thank you.
Uh, Professor Kumar, I think you're on mute.
Sir, you need to unmute.
Now I'm audible, right?
Yes.
I just wanted to add that, see, like there are two constitutional offices where the one is the office of the president and another is the office of the governor. So
Okay.
under Article 159, the governor takes office to defend, preserve and protect the constitution. And under Article 200 and the governor has the discretionary power under Article 163. It is there that the governor can use his discretionary power. But then here in this case, if you read Article 200 as Shruti has said it, it is very clear that if a bill is passed by the state legislature,
Mm.
goes to the governor, governor has only three options.
Yes.
Governor can give the assent, governor can return the bill, but
Yes.
if the governor returns the bill, has to send the bill back with his message. So
Yes.
certain constitutional provision or in this case, governor did not send back the bill with
Yes.
any message. And the third is the governor can withhold, and fourth is governor can reserve it for the president.
Yes.
There also the governor has to point out that on what ground he is preserving the bill for the he's reserving the bill for the assent of the president on what ground. So here
Yes.
all these things were neglected. The governor first just sat on the bill, if you can use this word. He just sat. He did not really take any decision for 2 years almost,
Mm.
right? And the timeline is given in that article. I don't remember the timeline, but it's two
As
years, more than two
Yeah.
years. I think Shruti has said
More,
that.
so actually, they went to the court basically in 2023 after 2020 year went by, 21, 22 went by, and 23 end they went after the state of Punjab verdict was
Ah,
pronounced by the Supreme Court. And sir, I'd just like to add here that governor has actually got three options only. He can, if he assents, it's fine. If he withholds assent, he's supposed to send the bill back. He cannot withhold and just sit indefinitely over it.
he cannot say it. It's
He
a
cannot.
there as soon as possible. The word is as soon as
Yes,
possible.
Yes.
yes.
And another thing also I would like to add here that the here in this case the governor only took a decision to send it back, and in the government of Punjab case which Shruti referred, it has been made very clear by the Honorable Supreme Court that the
Mm.
governor can use only one choice, one option. Governor
Right.
cannot use the two option. That once the governor returns the bill for the reconsideration of the legislature, and after the in this case state legislature reconsider the bill and pass the bill in the original form, then
Right.
governor referred it to the president. That is not allowed. I mean,
Mm.
and as you know, under Article 141, the governor, it is there that the decision of the Supreme Court is binding on all the subordinate court, and by the implication, it is binding on the office of the governor also, because constitution is not only the constitutional text, it is
Right.
also the judgments of the
Right.
interpretation of the Supreme Court,
Right.
right?
I think that wonderfully lays out the context of my next question, which is, in the 2025 Tamil Nadu verdict, why did the Supreme Court feel the imperative to intervene in the passing of state bills? Could you guide us through some of the implications of the Supreme Court judgment and how it tests the boundaries of doctrine of separation of powers in our federal setup?
All
See,
right.
okay, Shruti, you
Uh,
can take this, then
so,
I will come.
okay. Uh, so see, so the reason why the Supreme Court had to step in, I think Professor Ashutosh and myself have laid out the background
Yeah.
that for all these years he didn't do anything, and then when the Supreme Court intervened and got them to sit across the table, sort of, and when they took judicial notice under Article 32, and then when it said that you need to do something,
Right.
the governor, the governor returned 10 bills
Mm.
after the court had issued the notice in the matter.
Right.
And then he later reserved the 10 bills,
Mm.
for presidential assent. even after he returned the bills, the
Mm.
assembly passed the bills again without changing them and
Right.
sent it back to the governor, and governor again now sends it to the president for his assent. So
Right.
basically, inherently, it sort of disrupted the legislative sovereignty,
Mm.
and there is I mean, there was nothing that could be done. It was a complete legislative deadlock. What does the state do? How does it work if it cannot have the laws passed that it wants to? So in here now the Supreme Court under Article 142 stepped in, which allows Article 142 allows the Supreme Court to do complete justice.
Right.
And it is under this particular provision that the Supreme Court bench declared those 10 bills which were repassed by the assembly to
Right.
be treated as deemed to have received assent on the day they were submitted to the governor.
Right.
I
And
would,
this was the point which raised that controversy.
Mm.
Now how does it what is the implication, because that was the second part of your question, the implication of the
Yes.
verdict, and impact on the doctrine of separation of powers, given that India has a uh, federal setup.
Right.
The court felt that it needed to reassert the principle of cooperative federalism.
Mm.
And the governor, the role of the governor is not to act as a political counterweight to the elected state government.
Right.
It has therefore laid down some mandatory timelines,
Mm.
which is 1 month for the governor and 3 months for the president.
Right.
And the second thing it has done is it has insisted on reasoned order to be given by the governor or the president. Okay.
Right.
And thereby limiting the scope for political misuse in the entire process.
Right.
And second thing I would like to say here, after rebalancing the federalism aspect, is that there was a constitutional silence
Mm.
in Article 200. There is a constitutional silence because Article 200 says that the governor, as soon as possible, is
Mm.
supposed to return the bill. Now, here, it is the job of the judiciary to
Mm.
ensure that when there is silence in the constitution, the interpretation is done according
Right.
to the constitutional values,
Mm.
which is democracy, which is federalism,
Mm.
and the functioning of the constitution itself.
Right.
We cannot have a deadlock where we have the legislative business completely coming to a halt.
Yeah.
So with that, when the Supreme Court has stepped in, there it was to fill in this constitutional silence, and
Mm.
it is based on a normative conflict. Why? Because the governor was now acting as, was a part of the deadlock which occurred,
Yeah.
and it had to be overcome. This situation had to be resolved somehow. You can't have the governance coming to a standstill. And the third is that nowhere else in the Constitution of India
Mm.
is the the since the Supreme Court has laid down these timelines, the question can also be that is there any other provision in the Constitution which may conflict what the judiciary in this case has said? And
Right.
the answer is no. So, by filling in the constitutional silence, it is basically facilitating.
Right.
And it is not, whatever the controversy is.
like, I mean, also, yeah.
Yes, sir, please go ahead.
I would just like to add one thing as a student of political science. You know, in a democracy, the council of minister or the government executive is elected, whereas the governor office is not elected. And then, as Shruti said, that any democracy is called, democratic governments are called limited government,
Right.
limited responsible government. So, you know, limited means what? Doctrine of checks and balances.
Right.
So this is very much added because, and then you know that and the constitution has to, sorry, the constitution has to be preserved by the governor. So in this case, what governor was doing was not really helping out the cause of the elected government, and this has happened in other states also. That
Mm.
the constitution is being read literally
Mm.
and not be going into the spirit of the or the basic principles which govern a parliamentary system or basically a democratic government. That is there. As far as 2 points, I would just like to make. One point has been, I mean, let us Shruti take also the criticism. So
Hmm.
one criticism has been that under Article 145, if there is an interpretation of the Constitution, then it should go to a Constitution bench of 5 members.
Huh.
Here in this case, it was a three-member. Originally, it was a three-member bench,
Yeah.
but Justice Chandrachud retired, so then it became a two-member bench.
Right.
But then the Supreme Court is also the custodian of the Constitution. In
Right.
fact, as you know, the Supreme Court probably is the only court in the world which has which has jurisdiction even over the constituent power of the Parliament. So even the constitutional amendments can
Hmm.
be subject to judicial review.
Right.
So, and actually, to add to what Sir is saying, judicial review has been recognized as a basic structure in
Right.
so many cases. Keshav Nanda Bharti, BP single case,
uh,
which talks about the removal of the governor itself and the role
Yes.
itself talks about that. And then you have subsequent judgments. And here, the judicial review is not limited through a constitutional five-judge bench only.
Hmm.
Hmm. And also to let me add, federalism is also a basic feature. S.R. Bomai case 1994.
Yeah.
Federalism is also the basic feature of the constitution. And
Right.
we talked about cooperative federalism. We talked about smooth relationship. As I said at the outset, that the office of the governor was envisaged to be a link between the central government and the state government. But here you have a deadlock. And
Right.
another thing I would like to point out, that reference has been made about Article 143. The
Hmm.
Supreme Court has said that if the president has to withhold her opinion, as you know, president can still withhold the assent on any bill, and the bill would not become a law.
Right.
Then the Supreme Court has said that the president should refer the matter
Hmm.
about the constitutionality. If there is a question of constitutionality, the
Hmm.
president should refer the matter to the Supreme Court.
Right.
Probably that is something, probably that is not really, uh, that has not been taken very nicely. I know, like in any case, president can refer the matter under Article 143 under the advisory jurisdiction. The Supreme Court can give the advice. So why to bring in the president to seek the advice? I don't know what is the position of Shruti on this, but on this
Sir,
point,
yes, sir. So
uh,
I'll just also add to this. So in the judgment, they have said that when the matter has when the bill has been presented to the president,
Yes.
if he feels that there is a constitutional question involved in the bill, which
Hmm.
needs clarification, but not a policy consideration.
hmm,
Hmm.
Policy consideration, the party, the political
yes,
government has full right to intervene in. But if there's a constitutional issue involved in the bill, then the matter may be referred to the Supreme Court. Now, I know because you see, the president is a formal head and he is the head of the country. So, to really
hmm.
question his and to direct him is not correct as per
That,
the
that is
criteria.
what I was saying. That the president can, on
Yes.
her own, also can refer the
Yes,
matter
but
to the Supreme Court.
sir, we can have a little clarification here that since 143 opinion given by the Supreme Court is
No,
not
it's not
binding
binding.
on
It's
the
not binding.
president,
It's
it
not
is
Hmm.
binding.
only an opinion, an advice that he's seeking, and which
Right.
I think in a normal democratic, system should function in a very smooth manner where the each organ is giving respect to the other and taking help from the job that they are very good at. So if the judiciary can help with the constitutional question, why not? And if you feel it's fine, go ahead. If you don't feel it's fine, then reject it. You have your own opinion. Of course, the end of the day, the buck stops with the president after
No,
all.
but then Shruti, the president decision would be also subject to judicial review. Please remember
Yes,
that.
yes, yes,
It
yes.
would be
That can
subject
be,
to judicial
sir,
review.
any law is subject to judicial
So,
review.
so it's
Once a
not
law
that
is
the
passed,
president
it
can.
is open
So
to
right
judicial.
now, I think the Supreme Court position is very clear that you have an elected government, and
Hmm.
if the elected government, without the consent of the elected government, the legislature would not, because the government has the majority in the state assembly. So in this case also, in other cases also, in Delhi case also, the Lieutenant Governor, though Delhi is a union territory, that is another matter. So the Supreme Court has, of late, Supreme Court has taken this position that the office of the governor should not be within court misused. In this case of Article 356 also. whether it's a imposition of the president rule in Arunachal Pradesh or in Uttarakhand. In Uttarakhand, even the High Court of Uttarakhand, upturned the reverse the decision of the presidential proclamation. So that is the basic spirit behind the decision of the Supreme Court, that the office of the governor should not be used or misused
Yeah.
by the party in power at the center
Right.
to check the legislative process.
Hmm.
That is the basic thing. So probably, and but then, as you know, there is another case, as Shruti said, the state of Kerala has also gone to the Supreme Court, and there probably there is a three-judge bench. So, and the Supreme Court is not bound by its own decision, as you all know.
Yes.
So it would be in any case it would be reviewed. The President of India has also referred the matter under Article 143. Not this judgment. Many there are 14 questions. So that would also invariably the Supreme Court would be referring to the matter again, and let us see what is the final situation. But then uh, this, as a student of politics and constitutional politics, I teach Indian constitution. I think this is not a very healthy, uh, uh, you know, going on this healthy kind of. It's not very healthy to for the governor to come in the way of legislative bill, especially if the legislative bill is within the constitutional parameter. Here, the governor is saying that the subject is under the union list, under the list number 66 in the list
66.
one. But then the same governor earlier said that it falls in the under the list, the item number
State,
32 in the state
state
list
and concurrent list,
and the
yes.
concurrent list. So here you are having the two positions. So this is something, this looks very, let me say, very fishy also. And the governor continues in his office, and the matter remains there. So let us hope that the governor and the Sarkaria Commission recommendation was that the governor, the before appointing the governor, the chief minister should be consulted. Even in the other commission's report, in fact, in Tamil Nadu judgment also, the
Right.
Supreme Court has referred to the other commissions, Punchi Commission, Sarkaria Commission, and Law Commission also, about the need to have a kind of harmonious relationship between the center and the state, and the office of the governor can play a very important role here. And
So,
I'm sorry to say that all those recommendations have not been followed. Mostly
Sir,
the
I'll just add to this here, since you have brought in the commissions. See, the Sarkaria Commission gave its report in 1988 and the Punchi Commission way back in 2010. And they have, in detail examined the governor's role in the Indian federal scheme.
right.
Now, the Sarkaria Commission had urged the governor to act expeditiously on bills, because when you say Article 200 says as soon as possible the governor should return the bill or take whatever action, it is indicating expediency, that you cannot delay. There has to be an urgent action which is required. So referring to that, the Sarkaria Commission asked the governors that you should take action quickly. And they also said that any reservation of a bill for presidential assent should be done extremely sparingly, and only in those cases which had a sort of constitutional doubts.
Right.
And third, they had said that the governors have to act in accordance with the aid and advice of the Council of Ministers. I think that is
absolutely.
something which we have completely forgotten, that the governor, basic point is that they have to act on the aid and advice of the Council of Ministers. Similar thing was reiterated by the Punchi Commission in 2010, where the Punchi Commission also said timeline should be codified for the governor under 200 and 201. And secondly, they had criticized the politicization of the office of the governor, the manner in which the appointments to the governor office was happening, and they had warned that it will be misused. And the same thing, that governor should
Here
promptly.
I would like to add, Shruti, that the way governors have been appointed, like what happened 1977 when Janata Party comes to power, they sack all the governors and they appointed their set of
Yes.
governors. Indira
Yes.
Gandhi comes back to, I mean, Congress comes back to power in 1980. they do the same.
Same.
Then even VP Singh appointing the governor, and then the Congress Narasimha Rao government coming and then appointing their own governor. So it makes it very clear that the governors are just like a agent of the center, and that undermines the dignity of the office of the governor. The governors
Yes.
become, there are incidents where the governors have been seen in a very bad light. The imposition of the president rule. You have whole list from Brahmvira to Sri Pratasha to the Ram Lal and so many governors. They have not really covered themselves with glory.
So,
Absolutely, sir. And also, TL, just to finish, the National Commission for the Review of the Working of the Constitution suggested similar codification.
Venkatachalaya Commission, yeah, they
yes.
also suggested that.
Then I just want to point out, in the judgment, the Supreme Court has referred to an office memorandum,
Mhm.
which was issued by the government, central government, on 4th of February 2016, saying that the moment the bill is received, because see, you see, they have to take some action
Yes.
at the central level. It has to be the when it comes to the notice of the Home Ministry, whatever issue the bill is on,
Mm.
they said within 1 month, when the bill is with the governor,
Yeah.
within 1 month they are supposed to give whatever information so that the instructions can be sent accordingly. And for the presidents, when the bill is pending with the president, they gave the same timeline of 3 months. So
Mhm.
I mean, the central government itself has issued these directions of their own. So the
Right.
codification is also for smoothing the procedural functioning of the government themselves, which they have realized.
Yes.
And this is what it was.
Yeah.
This is very
So,
much related to democratic governance also. Yes, yes, I
yes.
agree. Yeah.
Yeah. So, in line with whatever you just said, do you think that the judgment is somewhat in line with the reports of these commissions that you mentioned, be it Sarkaria or um, Punchi Commission?
Punji Commission, Sataria Commission, and even
Absolutely.
the Venkatachalaya Commission, the review of the Constitution, they all emphasize, the very important judgment is the Bomai judgment, S.R. Bomai judgment, 1994. And
Yes.
there the Supreme Court referred extensively to the Sataria Commission report about the office of the governor.
Hmm.
And what about their recommendation? They said that the governor should not be from the state, governor should not be involved in the active politics of
Hmm.
late. Then
Yes.
they also said that the governor should not be removed. They should be under until unless there is an extraordinary reason for transferring them or removing them. Governor should be given a security of the position. But
Right.
what has happened
So
that
what you're saying was reiterated in the BP single case, which deals with the
uh,
removal of the governor, where they have, categorically held that BP, I mean, removal of the governor, because you see, then the governor has no option but to just behave like a puppet.
Yeah.
that appointment is very important factor. That the
Right.
security of the tenure is very important, because on other things, whether you refer to CAG, you refer to this the chief election commissioner, you refer to other positions, there is a security. The judges also, you
Right.
have a process. You need the affirmation from the legislature. Here
Yeah.
in this case, one telephone call, and then like the governor is. I mean, there have been incidents where even a secretary rank officer, I mean, if you go by the newspaper report, a secretary rank officer calls the governor that you please resign. I think this was a case of Uttarakhand or something. And the governor said that, I am the constitutional head of the state. And, Babu is telling me to resign. So he went to the Supreme Court. So these things are very important, that how do you, and the men of integrity, the office of the governor should not be a retirement post. It should not be a post where you just appoint someone who is not really doing well in politics, or you bring up political. I mean, as I refer to the Constituent Assembly debate, it was a very high hope. They did not give much power to the governor. Obviously, governor is not elected, but they always thought that the governor would be a very dignified person, very eminent person, and could be completely very important factor would be completely a non-partisan person. He would be
Hmm.
over and above the everyday politics and all this party. He would not associate himself closely with a party. But this has not happened, and not with this government. All the governments have. I referred Nasimha Rao government or Janta Party government, VP Singh government or Indira Gandhi government. Every time, even Nehru could not really follow this. Refer 1957, how the Kerala government, elected government of CPI, was removed. Was removed, and president rule was imposed in, and that was also done on the report of the governor.
Right.
So I
I
think
think
all.
the position of the governor needs a little bit of a relook constitutionally,
Yes.
so that at least their appointment and removal, because security of tenure is essential for any person to work fearlessly.
Shruti,
Right.
I think consultation should be there. No? Consultation
Hmm.
should be there with
I
the
think
government.
the commissions had sort of, recommended setting up of a collegium system
Mhm.
where you have the prime minister, the home minister, the speaker of the Lok Sabha. The Punchi Commission, I believe,
Correct.
had said that a collegium system with a wider consultative process, which consists of prime minister, home minister, speaker of Lok Sabha,
Just like
and
the
the chief
CBI
minister of the
director, just
concerned
like the
state.
CBI director or the chief
Right.
election
No, and they
commissioner.
had said the
Uh,
chief minister of the concerned state also
mm.
be sort of asked.
So, do you think that the present system of the appointment process of the governor undermines their ability to take autonomous decisions as of now?
So I
Shruti.
think, Tia, this is what we were just trying to convey,
Hmm.
that you appointment has to be based on some kind of a more open system,
Right.
where it is non-partisan,
Hmm.
Mm.
and I mean, you need to institutionalize some safeguards
Hmm.
instead of continuing with the process of unilateral appointments. So,
Right.
some kind of, I mean, let it not become a site for partisan confrontation, especially
Yeah.
where you have opposite parties.
Yeah.
And the BP single case, I think, is a very good case of 2010, where the Supreme Court has categorically said that president may remove a governor without assigning reasons, but
Yeah.
s- but such removal, it cannot be arbitrary or malified,
Right.
and you need some kind of constitutional objectivity in the appointment,
Right.
and so that the governor can act fairly and independently.
Right.
I think Surya Narayan case also, 1982, Shruti, Surya Narayan case also,
Okay, sir.
where the Supreme Court accepted that the governor can be removed by the president. But then there should be, as Shruti is saying, that there should be some, substantive reason for removing the governor or transferring him. It should not become just an instrument. Sorry to use this word. It should not become an instrument for, as Shruti said, that if the party in power at the center and the party in power at the state level are two different parties, then the governor should not be used as
It
an
comes a
instrument
ball.
to
Right.
and then you need governor also who should have the courage of character, that
Yes.
they but then
So
unfortunately there
the
is a
oath
whole
of the governor is to uphold the constitution. That's the
preserve,
primary
preserve,
responsibility.
preserve, defend, and
Yes.
protect the
And
Constitution.
if
159.
he cannot do it, if he
Uh,
is in a situation where he cannot do it, he has the option of making a statement through resigning.
Shruti said
On
that
this point.
federalism is a basic feature. Federalism
Yes.
is a basic feature. Judicial
So,
review is a basic feature. Yes.
with that, I think I can conclude with my last question, which is the overarching question, which you have already mentioned in your article as well, that governor remains an important constitutional functionary, and the state legislature and governor cannot remain in a deadlock in a well functioning democracy. So, what reforms can be possibly introduced to chart a way forward through which we can ensure the preservation of democratic norms?
I think Shruti has already said that the governor the appointment is very important. The way governors are appointed, there should be wider consultation, and
Yes.
there should be at least consultation by the consultation with the state government. Especially if the party in power at the state level is a different party. from the party which is in power at the center. And as you know, like federalism as a principle, we have a strong center framework in India. Let me
Right.
say that. And probably the Constituent Assembly members, they decided that the governor shall hold office during the pleasure of the president. That was also intended
Yes.
to keep the governor as the, what should I say, the central government man or woman. Right, that was there. But there is a limit,
Yes.
that you cannot really come in the way of an elected government or an
Yes.
elected legislature which
Hmm.
is passing a bill, which is making a law, which is within the parameter of the constitution. You are
Right.
just blocking it, and without any substantive question of law or any violation of the constitution or the violation of the high court jurisdiction or something that is mentioned there in article also. So there should be some very good basis, and that is what this judgment has said. That it says that if you are taking up, you are withdrawing, sorry, you are reverting the bill for the reconsideration, the governor should give a message. The governor should, and that is there in Article 200, that the governor should send back the bill, pointing out any provision or any constitutional question. Here
Right.
in this case, the governor reverted back the bill without any message. So you cannot do that, and the governor cannot withhold opinion, as Dr. Shruti said very clearly. And
Right.
as far as the president is concerned, if the president asks the state legislature to reconsider the bill, the president should give the ground on which he or she is returning the bill to the state legislature. And
Right.
then obviously uh, those grounds would be subject to judicial review. As you
Absolutely.
know that now even the emergency power of the president under Article 352 is
Hmm.
subject to judicial review, because the cabinet has to give written recommendation. What is the use of written recommendation? Because now you have
Yes.
a proof. Written recommendation can be subject to judicial review.
Hmm.
Earlier, Indira Gandhi just went there with Siddhartha Ray and got the proclamation passed. Right.
So they have a movie on this now.
Acha, there's a
Anyways,
movie
I'll just
also.
add to Sir's suggestions, regarding the reference to the appointment procedure. Of
Sure.
course, we all agree with that and we have discussed that. But
Yes.
I think first and foremost, this judgment has come, but we must codify the timelines.
Right.
Let the parliament itself take action. Why have it as a judgment? Why
Right.
not codify the timelines through an amendment to the constitution or a legislative codification
Like in
according
the
to
case of
their.
Visakha judgment, like in
Yes,
the case of the
let
Tara
it
judgment.
happen. And
Uh,
second, my suggestion is, if you look at UK,
Hmm.
you look at in the judgment also, they have referred to England, they have referred to Canada, they have referred to Australia.
Right.
In UK, the royal assent is automatic.
Hmm.
It is a constitutional convention operating in that country for more than 300 years. That it is unheard of that assent is to be withheld. No, it is not, because the primary job of making a law is with the elected representatives of the people.
Right.
My third suggestion would be to create some kind of a constitutional ombudsman,
Hmm.
a sort of a review council of the constitutional authorities, which is able to monitor the
Hmm.
conduct of constitutional functionaries. And such a body can comprise of former judges, constitutional experts, jurists, even retired governors,
mhm.
and they could act as a soft federal check,
Right.
similar to what you used to have privy councils, how the privy councils and intergovernmental bodies operate in federal systems.
Hmm.
So this is something that we can really explore at this stage, and if we really want to do something positive.
Second, I agree with Shruti's suggestion, but second suggestion, I have some problem. Like we have this interstate dispute going on, river water and the waterways and all. So somewhere I think you have to put a line, because
Right.
sometime, like in the case of Jammu Kashmir, I mean, or any other
So you
state.
have a problem with the making a constitutional convention?
No, I'm just saying that if a bill is passed by the state legislature, the government is elected government. They have a mandate. They have a electoral compulsion and all. So probably there is a need to put a check. So it's not that the governor power to ask the state assembly to state legislature to reconsider, or the president referring the matter to the president for reconsideration. That should be there, because
Hmm.
the sometimes the state parties, we have so many state parties and regionalist parties.
No, 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 you're
Yeah.
right, sir. I mean, in the sense that, as a, because what is happening is that legislative process is suffering. So let it then have be an exceptional situation which is defined,
Timeline,
which is
timeline.
very particularly
Yes.
defined.
Hmm.
Right. I think,
Timeline should be there. Yes.
yeah, I think we can all agree and perhaps conclude this session with your lines from the article, which state that the judgment should be viewed in the light of cooperative federalism, which is a very uh, principle which is increasingly foregrounded in constitutional jurisprudence in India. Um, and with that, I think we can call it a wrap to this particular conversation. Some incredibly important points raised about the historical context, the present judgment, as well as the pathways that we can take forward. I'd like to thank the audience for patiently tuning in. If you'd like to read more about this issue, the article that we're referring to is available on our website. We'd also like to request our audience to please support us, subscribe to us, and follow us on our social media channels. And a very warm thank you to both of the speakers for sharing their invaluable insights today.
Thank you, Thea. Thank you very much.
Thank you,
I enjoyed.
Tia. I mean, it was a wonderful opportunity by
Yes.
EPW. I think they are doing a fantastic job by taking up such issues of concern. And
Yes.
Professor Ashutosh, I always hold in great esteem, and it's such a
I
pleasure and
also
an
enjoyed
honor
the
to be
thing.
on the same
We
platform.
were writing together. I mean, there is
Yes.
another issue we have written recently, which would be published. This is
Okay.
one nation, one election.
Okay.
Yes.
Though EPW did not accept it, but it has been accepted by
I think we should disclose that.
right.
So, thank you. Thank you, everyone.
Thank you, and have a